Well, we have two more options in Parliament. The first is that we can send the bill to we can petition the bill. We can petition the President, asking him to send the bill back to Parliament to give us as MPs an opportunity to fix it, to get rid of the unconstitutional provisions and make sure that they comply with the Constitution. And that would involve us introducing the bill as a Section 76 bill so that the provinces have a chance to look at it as well, which didn't happen this time. But if that doesn't succeed, then we have a second option, which is to pull together a one-third of MPs in Parliament to petition the Constitutional Court directly, and then we can ask the Con Court to actually look at the law without having to go through the court system. That is one of the privileges Parliament enjoys under the Constitution, under Section 80.
Sure.
So we've still got those two options available to us.
All right, but let's look at the first option, because people are going to say, but what use is the first option? MPs have had this bill for many years, and they haven't been able to make the changes that they've wanted.
The problem we have is that this isn't the first time that Parliament has signed into law an unconstitutional act. And those acts get sent back to Parliament by the Constitutional Court after court cases have been brought by members of the public and civil society, and then Parliament has to rewrite them anyway. The best example is the Communal Land Rights Act, CLARA, which was sent back by the Constitutional Court for the same reason, because it was incorrectly processed. It should have gone to the provinces first. So it doesn't follow that just because Parliament has processed the law that the majority party has taken the right decision about its constitutionality. And we believe it's the same case over here. As with Clara, we fought it and we said it was unconstitutional, but the ANC used its majority and it prevailed, and the Constitutional Court sent the law back. It's also not the first time that we've petitioned the President to send a law back to Parliament. Even Kgaleo Motlanthe, when he was acting President, sent back a number of bills. So did President Mbeki, sent back a number of bills after being petitioned by MPs, because before signing them, he had a look, he took legal advice, and the legal advice came back with the conclusion that they were unconstitutional. So it's not in the President's interest to sign into law bills that haven't been processed properly. Sure. And he has a chance to send them back.
But again, clarify issues for us. There have been hundreds of changes made ever since this bill was first taken to Parliament. What exactly concerns you now?
This bill is so much better than it was when it first came to Parliament. It is a whole world away from where it used to be. There are two concerns that we have left. The first is that we're not 100% convinced that the public interest defense as it stands is enough to pass constitutional muster. The second is that we're not happy with the way that the bill was processed. We said so from the very beginning, that the provinces need an opportunity not only to have public hearings, but to actually process the legislation as a Section 75 bill. Parliament can introduce bills either as Section 75 if they're only national, or if they affect the provinces as Section 76. And each and every province has a say in the legislation. Now, this bill affects the way provinces process their own documents and their own information, but they never had an opportunity to process the legislation. So for the same reason that Clara was sent back, because the provinces weren't given a chance to make inputs, likewise, the Protection of State Information Bill is unconstitutional. So those are our two major concerns, and that's what we're going to be seeking advice about.
And just on the first concern that you've raised, the public defense clause here, and Mr. Cecil Burgess is going to come through in a short while just responding to what you're saying. And he's said this to me before, that all over the world, they've set high and low to check whether anyone can do anything more than what they've done in terms of this clause here.
Yes. Look, if international benchmarking was the only basis upon which we worked, then that wouldn't be a very helpful way for us to write the bill. It has to comply with our Constitution, which prizes transparency first before it prizes classification. So there are many arguments to be made about whether or not other parts of the world do it, and that's fine. But what this law has to do is comply with our Constitution, which, as you know, is possibly one of the best constitutions on earth, particularly because of the way that it prioritizes transparency and accountability, and it prioritizes public freedom of speech.
Okay.
So if this bill doesn't comply with the Constitution, it needs to go back to Parliament.
All right.
Whether or not that constitutional compliance is or isn't similar to other countries.
All right. Ms. Mzbugo, you may want to stand by then and listen to the responses by Mr. Cecil Burgess, who's the chairperson of the Joint Standing Committee on State Security. A very good morning to you, sir. Mr. Burgess. Mr. Burgess, are you there? Right. We seem to have a problem. I certainly will try and get back to that particular, because we would like to hear the reaction then of Mr. Burgess after hearing what the Democratic Alliance has had to say on this matter. Just get their thought on this matter. And I mentioned a little earlier on that they have said to me over and over again that there's been international benchmarking, especially when it comes to the issue of the public defense clause that people have been demanding, that they've searched all over the world and they've not been able to come through. In fact, they're saying that countries that have had this kind of clause have gone back and have decided to retract it in certain instances. I think Mr. Burgess is back on the line. Mr. Burgess?
Yes, good morning.
Sorry about that. We seem to have lost each other somewhere along the line. I wanted you to respond to what the Democratic Alliance's parliamentary leader was talking about. She was saying that there is a possibility that the president may send this bill back into parliament. Presidents have done so before, and that they are confident that that may happen.
Kulani, the process that the president can follow is set out in the Constitution. There's no basis for any political party to force or petition the president. And the only basis on which the president can send a bill back is if he himself sees that there are reservations regarding constitutionality.
And so, the public defense issue, again, as far as the DA is concerned and other political party, is a point of concern and that it may not pass the constitutional muster.
Yeah, well, that might be their legal opinion, but as I've said to you before, we have taken so much interest, we have done so much research on this issue, and I don't think you'll find a decent and a reputable lawyer in South Africa or an advocate today in South Africa that will conclusively tell you that that public interest clause, the absence of it, makes the bill unconstitutional.
Right, and
it can't be the case. But I think, Kulani, look, there's a couple of issues that your previous speaker said that is incorrect, man.
Yeah.
The provinces went on public hearings. They had public hearings. And the DA has been complaining about this not being a 75 bill because of archives. If they think that is the case, then they must take the thing to court. We have done our work on the matter, and we are satisfied that this is a 75 bill. It didn't need us to consult in the manner on this public, this archive thing that they're complaining about.
Explain that.
Public hearings. It's not correct.
Explain that for us, if you may, because I think it's a parliamentary procedural issue. 75 bill, what does that mean?
A 75 bill is a bill that does not contain matters that needs to go to the provinces, where the provinces have to go out on public hearings on a specific thing where the bill is going to affect provinces. There's a small matter regarding provincial archives or archives other than national archives. It's not the focus of the bill. Now, where there are matters that involve the provinces, it becomes a 76 bill, and then you have to go and consult the provinces because the matter concerns them. Those are 76 bills. This is not a 70. The information bill is not a 76 bill.
Okay. So is that where the comparisons with Clara is coming in?
Look, you know, this issue about, you must understand, Kulani, we have a constitutional court, we have courts. If people are unhappy about bills, happy about laws that Parliament passed, then they must exercise. The Constitution gives them all that right. There's another fallacy that you've been told there, you know. A bill is a bill. It only becomes a law once the president has signed it. Nobody can take a bill to court. Nobody. It doesn't matter whether you're a political party, who you are. You cannot take a bill. You can only take a law to court. This 1/3 majority or 1/3 of the members of Parliament that your previous speaker is referring to, they cannot take a bill to court. Only once the president has signed the thing, then they can take it to court.